This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about acts of nature, because rust is an act of nature, and just about everyone in the world should know that cast iron pipes will rust and thereafter leak. And as a result, insurance companies have naturally excluded leaks from pipes that rusted over a long period of time because of acts of nature. When water and moisture meets iron pipes, they tend to leak and rust all the way through. Well, Marisol Rosa appealed a final summary judgment entered in favor of her homeowners insurer, Safepoint Insurance Company, in a November 14, 2022, Florida Court of Appeals 5th District decision. The Court of Appeals interpreted an exclusion for damages caused by an act of nature. The Safepoint insurance policy insured Rosa's dwelling pursuant to a homeowner's policy. The dwelling was damaged by the overflow of water from the plumbing system. The parties agreed that the loss resulted from the deterioration of cast iron pipes that was caused by rust or other corrosion. After investigating the damage, Safepoint determined the loss was excluded from coverage under the policy's Water Damage Exclusion Endorsement. Rosa then sued, seeking to recover the costs she incurred in repairing her dwelling due to the water damage. The issue in the appeal was whether the policy covered the subject loss, and the answer depended on the meaning of the term, quote, act of nature, close quote, in the policy. The introductory paragraph of the policy's exclusion section stated that the policy does not insure for loss caused directly or indirectly by any of the following, and that such loss is excluded, regardless of any other cause or event contributing concurrently or in any sequence to the loss. It defined water damage following that introductory language and replaced by an endorsement which defines water damage as including, quote, accidental or intentional discharge or overflow of water or steam from within a plumbing, heating, air conditioning, or automatic fire protective sprinkler system, or from within a household appliance caused by or resulting from human or animal forces, or any act of nature. Thus, if the rust or other corrosion that caused this loss was an act of nature, Safepoint correctly denied coverage. But if the rust or other corrosion was not an act of nature, the Water Damage Exclusion Endorsement did not preclude coverage. The interpretation of an insurance policy, at least in Florida and in most states, is a question of law reviewed de novo. That is, they review as if it was presented to the Court of Appeal for the first time. The guiding principle for insurance policy interpretation is that the policy must be read as a whole, affording words their plain meaning as bargained for by the parties. Florida law provides that insurance contracts are construed in accordance with the plain language of the policies as bargained for by the parties. The insured argued that act of nature was synonymous with act of God, and only occurs when a singular act or external force occurs, like an earthquake or a hurricane. However, everyday interpretation of the phrase act of nature is not as narrow or technical as the insured's proposed, but rather is to be given its ordinary meaning as something that naturally occurs. the Court of Appeal found that in the context of the policy, the phrase act of nature does not require an uncontrollable or unpreventable event. Here the loss was caused by rust or corrosion. Corrosion, the chemical reaction between iron and moist air, is an act of nature or a naturally occurring force. Thus, the rust or corrosion occurred because of a natural act. As a result, the court concluded that the Water Damage Exclusion Endorsement applied to the loss. Such losses are excluded even if they were caused concurrently by a covered peril. In context, any act of nature is not limited to natural disasters such as an act of God. The policy at issue referenced an act of God more than once in its cancellation and non-renewal sections. Where the document, the policy, used one term in one place and a materially different term in another, the presumption that the court must follow is that the different term denotes a different idea. As a general proposition, the use of different language in different contractual provisions strongly implies that a different meaning was intended. In light of the entire policy, the use of an act of God and any act of nature separately indicates each phrase has a different meaning for the purpose of the homeowner's insurance policy. Relatedly, the choice of the drafters to capitalize an act of God stands in contradiction to the uncapitalized use of, quote, any act of nature, close quote, in the exclusion. The distinction further undermines Rosa's argument that the terms any act of nature and an act of God are interchangeable within the policy because the phrase any act of nature is made expressly applicable to the Water Damage Exclusion Endorsement. The Court of Appeal concluded, therefore, as is required by basic insurance policy interpretation rules, that the phrase is to be given its ordinary meaning. In sum, the court concluded that the rust or other corrosion that occurred in the pipes at Rosa's dwelling, regardless of whether it was perhaps preventable or controllable, was naturally occurring force and thus an act of nature. And as an act of nature, the loss came within the policy exclusion for any act of nature. Consequently, Safepoint correctly denied coverage. In my opinion, insurance policies are always interpreted by reading the entire policy to make sense of the intent of the parties. Since the term act of nature only appeared with regard to the water damage exclusion, and act of God appeared elsewhere, it was obvious to the court that the terms had different meanings. Rust is natural when moisture and air meet iron. It exists naturally in hillsides as well as in iron pipes and other pieces of iron like an old car. The cause of the loss was the rust that caused the insured's pipes to leak and cause her damage. No insurance policy insures against every possible risk of loss, and the cause of the loss was clearly and unambiguously excluded. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog, and it allows you to subscribe to the blog so that you can be advised of every blog posting, which occurs normally at least once 5 days a week, sometimes twice. These videos are also available on YouTube and on rumble.com, and you may view the videos at any time you wish. It is also free on the internet, and I would appreciate it if you subscribe to either Rumble or to my YouTube presentations, and advise your friends and colleagues that they are available to view and subscribe. And you might also find of interest my locals community and my Substack publications, where special to subscribers only are things published that would be useful to anyone interested in the business of insurance or insurance claims. Thank you for your attention.